I make it plain to you and to others that the sentence of the court will be imprisonment for life in the case of you, Moore. In respect of you, Griffin and Douglas, it will be detention at His Majesty's pleasure, because of the ages you were when you committed the crime of murder. You were both under 18 years. I am required by law to impose those sentences. I am also required to set the minimum term you must each serve in full before you are able to apply to the parole board for release on license. You may only be released if the parole board consider it is safe to do so. That time will be many years ahead. The sentences of life imprisonment and the sentence of detention at His Majesty's pleasure, which is in effect a life sentence, are designed to protect the public. It is clear from the personal statement of the mother of the deceased that he was much loved by his family, and his death has had an extremely adverse impact upon them. It is clear they appear to have been unaware he was a drug dealer. You, Griffin and Douglas, have no previous convictions. In your case, Douglas, there is a conditional caution for possession of a Class B drug with intent to supply. I shall ignore that. I must take into account you were both drug dealing via the Frank line, but you have no convictions. In your case, Moore, you have several previous convictions, which include possession of an offensive weapon in a public place, possession of drugs, offences of assault, including assaulting emergency workers. You also have cautions for crimes of violence. I note this previous criminality, but it is not going to govern or influence the sentence in this case. You were a drug addict. You were also an alcoholic. You had, as a consequence, a close connection to drug dealers and the Frank line. If ever there was a case that demonstrates the twin evils of drug peddling and carrying knives, particularly young people carrying knives, this is it. Second, this case demonstrates what can happen when young people get embroiled in drug peddling and a drug-related turf war erupts. Third, this case reveals how important it is that those in authority do what they can to educate the young and warn everyone about the consequences of having a knife in a public place. Fourth, it must be made clear that even though an individual may intend only to inflict grievous injury on another person, if that other person dies as a consequence, the perpetrator is guilty of murder and faces a life sentence with a long minimum term to be served. Fifth, this case also reveals that to be convicted of murder, it is not necessary to be the individual who executes the attack. Any person who participates in the killing by way of setting it up or assisting the actual killer or killers, providing he or she has the requisite intention, he or she is also guilty of murder. Sixth, in this case, a young man has lost his life. Regrettably, he was peddling drugs. Two other youths have now wrecked their own lives, and a woman in her early 20s has also sabotaged her life. The latter three are all murderers and are facing life sentences with long minimum terms. Two of the murderers were involved in drug peddling via a drug line, in this case called the Frank line. The other is a drug user. This murder was perpetrated as a means of seeking to protect the drug peddling agency. Seventh, I am satisfied that the two teenage youths who perpetrated the killing were recruited or corrupted to enter the fetid swamp of drug dealing. They did not set up the drug line. However, once recruited and involved, they wallowed in that swamp and had large knives to assist them in their criminal tasks. Eighth, the sex worker, who is the third defendant, was a drug addict and as such was closely connected to drug supply. Her life was squalid. I have little doubt she was exploited. Her life was comprehensively disordered. All three of you committed murder. The backdrop to the murder is unquestionably a manifestation of drug-dealing turf wars in Sheffield. The deceased, Sacad Ali, it would appear, had started to trade in drugs in the area of Sheffield dominated by the Frank line, as it was called. He was murdered because of this. You both, Griffin and Douglas, are drug dealers within the Frank line. In your case, Moore, you are a drug user, but closely allied to dealers. You used the Frank line to obtain crack cocaine. All three of you hatched a plan to inflict grievous bodily harm upon the deceased. It is clear that you, Griffin and Douglas, acquired knives and took these large knives to the scene with a view to violence being visited on the deceased. I will make findings of fact as to whether you, Moore, knew of those knives in the possession of the other two defendants. The actual act of killing was perpetrated by you, Griffin and Douglas. The murder was set up by all three of you. It was your task, Moore, to lure the deceased to the location of his death in the park by an offer to buy drugs and to have sex with him. You were a sex worker at the time. You were nearby when it was perpetrated by the other two. The deceased was stabbed many times by both of you, Griffin and Douglas, wielding large knives. It was 2 onto 1. It is right to say that the deceased had a knife too. He, however, was overpowered by you both, and despite pleading for his life, you murdered him. You left him there to die, and he bled to death as a consequence of a particularly serious wound to his leg, which severed a main artery and vein. There were 16 separate stab wounds of different types. He was stabbed repeatedly. He collapsed within about 30 seconds, as appeared on the CCTV recording of those shocking events in a public place. He was declared to be dead about 40 minutes later, after attempts were made to resuscitate him. The three of you thought the deceased was dealing in drugs on your patch. he was attacked to stop him from continuing to sell drugs in your area. The deceased was plainly backing away as it was 2 onto 1. Both of you, Griffin and Douglas, were striking out at him with equally big knives. 6. You more remained. You stood where you were, which was about 30 meters from where the attack was taking place. You observed it, and after a short while left the scene. 7. The deceased was shouting and screaming. This was heard by nearby residents in the block of flats. One witness saw the deceased trying to defend himself and recalls him saying, quote, "All right, lads, now I'm hurt, leave it," unquote. He was plainly exclaiming for him to be left alone. You both stabbed him, and he went down. It was a determined attack perpetrated by you both. That is clear from the CCTV recording of the events. You then left. 8. In consequence, I have formed the following conclusions. 1. The reason for the attack on the deceased was entirely due to him seeking to deal drugs on the patch occupied by the Frankline drug dealing agency. Drug dealing turf wars has suffused this case from start to finish. 2. I accept the proposition that this drug line or supply enterprise was not something which any of you established. 3. Both of you, Griffin and Douglas, were drug dealers within the Frank line. 4. I am satisfied that you, Moore, were a drug user and not a drug peddler. You were, however, closely allied to drug peddlers at the home of Thornhill and elsewhere by reason of your hopeless addiction to Class A drugs and alcohol, as well as being a sex worker. 5. In your cases, Griffin and Douglas, you have been friends for many years. Both of you were talented football players as youths. It is a tragedy that you did not continue with the camaraderie and support of that sport. 6. You are both immature and have had a raft of problems in your young lives as set out in the various reports. Neither of you has previous convictions. I have ignored the youth caution. 7. This is a case where you all had an intention that the deceased should have been caused really serious injury. None of you harbored an intention to kill him. It is my judgment that there is evidence to suggest that you, Griffin and Douglas, were corrupted and exploited by other criminals involved in drugs to operate and materially assist with drug dealing via the Frank line. You, however, were not peripheral participants in this. You were fully involved with it. You were both drug dealing. 9. I am sure that both of you had an easy way with knives and had these knives about your person on 8th and 9th March 2024. You had these knives as an integral part of your drug dealing operation. 10. In forming my views about you, I have paid attention to the guidance of the Sentencing Council in respect of young offenders, in particular about assessing real maturity as opposed to an assessment of it purely by reason of your chronological ages. It is my view you are both similarly immature and similarly streetwise. 11. This was a planned and premeditated attack. That is an aggravating feature. You planned this because of the encroachment on your drug-dealing territory. 12. You both visited sustained violence on the deceased by several heavy blows and stabs with large knives, whilst the deceased was trying to get away. It was 2 onto 1. It may be that the deceased got out a knife moments before you did, but you both then pursued him with determination and vicious force. The fact that you, Griffin, appeared to strike more blows is immaterial. You were both in this together with equally big knives, which you both used with vicious determination. 13. I accept you were both intoxicated, but you knew what you were doing. It may have given you the impetus to do as you did. 14. I have well in mind the submissions made by counsel representing each of you. 15. This was a group attack. 16. Your role, more, was to lure the deceased to the location. You were a participant in the murder, but you did not inflict the fatal injuries. Your role was, however, pivotal to the plan of attack. It was not peripheral. 17. You too were affected by alcohol and drugs. 18. I am very conscious of your mental health and lifestyle, but that offers some mitigation, but not potent mitigation in the context of this case. 19. You have previous convictions, which I note. You are no stranger to violence. These convictions remove your good character, but will not govern the minimum term in this case. 20. In your case, Griffin, I accept the submission of Mr. Rhodes about the, quote, fairness, unquote, point, resulting in you being sentenced later than you expected and losing a potential advantage thereby. It is, however, by no means certain you would have been released at the halfway point of the minimum term. I also take the view that there is an element of unfairness to you that your co-accused, who is a little younger than you, has a lower starting point than you when I adjudge you to be similarly immature and similarly culpable. The starting point is just that. I must endeavour to reflect the seriousness of the case on an individual basis and exercise judgment. The starting points are not designed to be hermetically sealed compartments. I shall make a modest adjustment to reflect these points, but I cannot ignore the clear will of Parliament. 21. In respect of the possession of a bladed article, I shall pass a concurrent sentence of 12 months detention in each of your cases, as the case falls into category A1, where a sentence of 18 months would have been passed following a trial. The sentence would have been higher had you been adults at the time. 22. I have already set out the starting points at an earlier stage of these sentencing remarks. 23. The guilty pleas of you, Griffin and Douglas, will be reflected by reductions of 1/6 to the minimum terms. Having regard to the circumstances of this case, it is my judgment that the following minimum terms are just and proportionate. In your case, Griffin, the starting point is 23 years. In your case, Douglas, the starting point is 17 years. You both intended to inflict really serious injury, which serves to reduce that term. I also have well in mind the important points of mitigation concerning your immaturity and the contents of the reports. There are aggravating features of the case which I have identified. In your case, Moore, the starting point is 15 years. I am very conscious of the role you took and the fact that you did not personally inflict any injury of the deceased. Your role was pivotal to the plan. I appreciate your personal background, which is comprehensively baleful, but you do not have the advantage of a guilty plea. You forced a trial. Sentence. In your case, Griffin and Douglas, the sentence of the court will be detention at His Majesty's pleasure. In your case, Moore, the sentence of the court will be imprisonment for life. In each of your cases, this means a life sentence. The sentence I pass upon you must be expressed in a particular way. I will set out the minimum terms to be served, which must deduct the number of days you have been on remand from that in order to produce the final exact term. Those calculations can be done in one moment. In your case, Griffin, my analysis is this. The starting point is 23 years. The various mitigating features reduce that to 19 years. The various aggravating points increase that to 21 years. However, the, quote, fairness, unquote, point, as it has been colloquially called, reduces the minimum term following a trial to 20 years. 1/6 reduction reduces the minimum term by 3 years and 8 months. In fairness to you, as you are in exactly the same position as Douglas, I propose to modestly increase the reduction to 4 years. The minimum term in your case will be 16 years. In your case, Douglas, my analysis is this. The starting point is 17 years. The various mitigating features reduce that to 15 years. The various aggravating points increase that to 18 years. 1/6 reduction reduces the minimum term by 3 years. The minimum term in your case will be 15 years. It will be appreciated that I have endeavoured to achieve a level of equality in each of your cases, Griffin and Douglas. That cannot be perfectly achieved despite my view you are almost identical in terms of your personal circumstances and your culpability. I cannot ignore the will of Parliament by reference to minimum term starting points, but I have sought to do justice in each of your cases. It has been a difficult task. I cannot emphasise enough, the assessment of the correct minimum term is not a precise arithmetical exercise. It is the exercise of judgment to reflect the seriousness of the case. In your case, Moore, my analysis is this. The starting point is 15 years. The various mitigating features, in particular that you were an accomplice and not the one executing the attack, albeit you were pivotal to the plan, reduces that to 13 years. The various aggravating features increases that to 15 years. The minimum term in your case will be 15 years. I will formally pass sentence upon you once the necessary calculations have been undertaken to express the sentences in the way required by law. In each of your cases, I impose the necessary statutory charges where appropriate. Thank you. So the sentences can be passed in the way that I've indicated, and those are the minimum terms precisely. Very well. Thank you. Will you all stand up, please? In your cases, Griffin and Douglas, I have already indicated the sentences in respect of the possession of the bladed article will be terms of detention of 12 months. I impose that on each of you concurrently with the sentence I am about to announce. In your case, Griffin, the sentence I pass upon you is one of detention at His Majesty's pleasure. I direct that the minimum term you will serve to be 15 years and 106 days. In your case, Douglas, the sentence I pass upon you is one of detention at His Majesty's pleasure. The minimum term I direct you serve is 14 years, 106 days. In your case, Moore, the sentence I pass upon you is imprisonment for life. The minimum term in your case is one of 14 years, 106 days. I impose the necessary statutory charges where appropriate. Take them down.